Jharkhand's mining secretary and senior IAS officer Pooja Singhal arrested in connection with the embezzlement of crores of Manrega funds, charged with irregularities while serving as a district magistrate between 2007 and 13. UP's DGP Mukul Goyal is removed from his post, accused of neglecting work, disobeying orders. Top cop Goyal now made DG, Civil Defence. Communal tension simmers in Rajasthan's Bhilwara after a 22-year-old Hindu boy was allegedly killed. Police detained 3 minor suspects. Morgan Stanley lowers India's economic forecast to 7.6% for FY23 and 6.7% for financial year 24, cites global slowdown, surging oil costs, reduced domestic demand for the growth trim. And no end to the crisis in Sri Lanka. Army deployment stepped up across the island nation. Government refutes reports of ex-Prime Minister Mahinda Rajapaksa fleeing, says leader has been moved to naval base for security reasons. But tonight, we start once again with the Supreme Court, where a historic order was passed by a 3-judge bench headed by Chief Justice Ramanna. The apex court put the controversial sedition law on hold. It has directed the centre and states not to register any new FIRs under Section 124A, which is the sedition law. The Supreme Court decision could anger the central government. It says, or so said the law minister, that there is a Lakshman Rekha that needs to be respected by all organs of the state. But clearly, the judiciary has sent out a firm message. A colonial law by which people can be arrested easily by state and central governments and where police file random FIRs at times needs to go. Anisha Mathur has tonight's top story.
It is a historic day for India. Section 124A of the Indian Penal Code, the British Raj-era sedition law, often used by the state to target dissent, is on hold. A 3-judge Supreme Court bench of Chief Justice of India, N.V. Ramanna, Justice Surya Kant and Justice Hima Kohli has ordered the sedition law be kept in abeyance till the Narendra Modi government re-examines its provisions. In its interim order, the Supreme Court says it hopes and expects the centre and state governments that they will stop filing FIRs under the sedition law during this time period. All pending cases and appeals under Section 124A will be kept in abeyance. Those who are already booked or might be booked under the law can move court for relief. The court has allowed the union government to issue a directive to states to prevent any misuse of the law. In its order, the Supreme Court cited the government's affidavit on Monday that stated it will re-examine the clause. The court said it is clear that the Union Government of India agrees with the prima facie opinion expressed by this court that the rigours of Section 124A of IPC is not in tune with the current social milieu and was intended for a time when the country was under the colonial regime. During the hearing on Wednesday, the government was not in favour of putting the law in abeyance. Solicitor General Tushar Mehta informed the court a draft direction for states was ready. It proposed sedition FIRs be filed only after clearance by an officer at the level of Superintendent of Police. The SG said bail pleas in pending sedition cases can be decided by the courts quickly. The Supreme Court will take up the petitions again in the 3rd week of July.
Important thing is that the Supreme Court, though, has stayed and restrained all the state government and the central government from registering any FIR under Section 124 of IPC. The moot question is what would happen about the pending cases.
All those accused would be therefore amenable for an immediate release on at least interim bail. That is what I understand. Till this 124 is resolved and the government comes back, whether they are taking it out of the statute book or not.
While the petitioners welcomed the order, the union government did not seem too pleased.
We respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other. Whatever we say, whatever we do, we have to ensure that we respect the provisions of the Constitution of India.
अब जनता उठ चुकी है। जनता की आवाज को ना कुचला जा सकता, ना उसका दम घोटा जा सकता, ना उसे दबाया जा सकता, क्योंकि राष्ट्र धर्म में सरकारों की आलोचना और शासकों को सच का आईना दिखाना हमारा धर्म है।
The Supreme Court order brings relief to hundreds of people who are booked for sedition, including activists, politicians, and journalists.
A lot has been said and a lot will be impacted by this particular verdict, and it now remains to be seen what will the government do next, as it has begun the process of reconsideration of sedition law. In New Delhi, with cameraman Ashwini Hillan, this is Anisha Mathur for India Today.
Now, why is the sedition law contentious? Let's explain it. It's sedition because it's been used arbitrarily and often to crush dissent or criticism. Even cartoonists, journalists, environmental activists have been hit with sedition. Between 2010 and 21, 867 sedition cases were filed across India. 13,306 people were booked in these cases. And here is a telling stat. In the period between 2016 and 2020, there have been only 7 convictions. So only 7 convictions, and you've got these hundreds of cases being filed. Now, all political parties in power have used the sedition law to crush dissent. Of the 867 cases filed between 2010 and 21, 559 or 65% were filed in 5 states. Bihar saw 171 sedition cases filed. Tamil Nadu saw 143 cases filed, UP saw 127 cases filed, Jharkhand 64, Karnataka 54. Source Article 14 NCRB and Rajya Sabha answers. Let's raise the questions. End of the road, therefore, for sedition law or not? Will the government now act on its promise it has made to re-examine this law? Has the Supreme Court done what the executive failed to do? Big step forward for the country in the battle for free speech? Yes or no? Joining me now is Mahua Moitra. She's there as a Trinamool Congress MP, but importantly today as also one of the petitioners in this case. And Aryama Sundaram, senior lawyer, Supreme Court. Appreciate the two of you joining us. Mahua Moitra, do you see this as a victory today for free speech? Or do you believe it's only a temporary respite, given the fact the government has said it's re-examining the law? The law is still there, or is going to be there in the future if the government so chooses. How do you see today's order?
Rajdeep, it's definitely a step in the right direction. And I would say it is a historic day because look what happened. 1962 was the last time that the Supreme Court examined this. The government says that this law is necessary and with reasonable restrictions. But in 1962, a 5-judge bench of the Supreme Court already laid down what it said were reasonable restrictions to the misuse of this law and said that imminent lawless action, incitement to violence for subverting government were the only times this law could be used. So mere criticism of the government and mere using constitutional means to protest or to dissent could not be termed as sedition. But we've seen in the last 5 to 7 years that obviously the 1962 judgment has been thrown out the window, and governments all over India, state and central governments, have used this law as a tool. In fact, the British used it to throttle Indians' voices, and the Indian government, an elected Indian government, has done exactly the same thing. So it is important today that
may I add, Mahua Moitra? No, ma'am, including state governments, because when it comes to free speech, you've seen even the Trinamool government has clamped down on those who have been critical of you.
Rajdeep, let me finish. Why are you getting so excited? Let me finish. Yes. Obviously, police is on list 2 in the constitution. Obviously, it's a state subject, so obviously state governments will do it more. That's pretty obvious. That's not the point. The point is because the law existed, there was room for people to misuse it. This law should not exist. And the most important thing here is that the government has come in and said, first the SG and the AG were on different platforms. The Attorney General was ready to argue. The Solicitor General says, please leave this. The court has no business looking into it. The government then comes in after 8 years of being in office and says, we will reconsider it. Please note, they use the word reconsider, not revoke. What is to stop this government, and we have seen this in the past, from their brute majority, from bringing in a revised version of this with amendments rather than revoking it, and amendments like silly ones like the one they put up in court, which is to say an officer of the rank of an SP or above can look into it on a case-by-case basis. That's just carte blanche to misuse it again. What the court has done, Gopal Shankar Narayanan, who was appearing for me in the case, put in a one-page submission in which he said, let the central government go in and reconsider it. Beware, they have not even put in a timeline. So it might take months or years or whatever. And the government cannot place on affidavit what Parliament is going to do. The government cannot do that. So Parliament alone can legislate. Given that we do not know what timeline we are looking at, the Supreme Court has said that no new FIRs can be filed on sedition, and people who are in jail for sedition, people who have been arrested, have the right to recourse. In immediate recourse as in bail, and all chief secretaries, all senior police officers have been informed that this is the situation. So I think this is definitely a victory. Of course, this is, historic.
You know, it is historic, but I will just press you one more time before I turn to Aryama Sundaram, just to say this. Do you therefore concede at one level that the state governments, it is not just the Modi government's problem, it's also state governments across the country who have misused it. No, 1 minute. We've seen Uddhav Thakkre's government in Maharashtra used it against Navneet Rana, a political rival, for reciting Hanuman Chalisa. We saw last year how the Delhi police was used to arrest Disha Ravi, an environmental activist. We've seen in the context of free speech, misuse of other provisions by your government to arrest a cartoonist who was critical of Mamata Banerjee. My point is, if the attitude, the mindset of the state does not change, the police will be used as an instrument.
No, that's exactly why we need this law to go. And let me place on record, the cartoonist was arrested under 66A, which has now become infructuous, not under sedition. And West Bengal, since 2014, since our government came to power, has only 10 cases of sedition filed, which again, had this law not existed, should not have been filed. So there's no question that the state governments are using it, because obviously this is police is on list too. So obviously state governments will use it. That's number one. It's not a question of, which pot is blacker than the other, or sort of, who's more to blame. The question is, when you have a law that has no place in a modern constitutional democracy like ours, the law needs to go. If the law exists, everyone is under temptation to use it. So the law is bad, and we need this law to go, which is exactly what the first step the Supreme Court has taken.
Aryama
Sundaram, the central government
just a minute, ma'am, now.
Accepted it. The central government should not have tried its best to stall it, and the intentions of the central government are clearly not above board. Even now, they're doing their best to come up with all these red herrings. They should just
Aryama
say,
Sundaram,
what?
Is it bad? Is it bad in law? Do you believe that effectively what the court has said today? They spoke about the social milieu. They believe that this law, in the present social milieu, is a law that should not exist on this. Just a minute, ma'am.
Yeah.
Let Aryama Sundaram.
Rajdeep,
is it prima facie, according to you, the court's message to the government now that this is unconstitutional, or is the court waiting to see what the government does? They've said we hope and expect that the government will act on it.
Look, Rajdeep, I'll tell you, there's a very simple issue here. You have a section 124A which deals with sedition. Now, one can understand sedition as being something which is necessary to see that nobody attacks the sovereignty, integrity, security of the country. Not a political party in power, not the government of a day, not criticizing policies of government, etc. That is not sedition. What sedition ought to be is really something more akin to threatening the security, integrity, the sovereignty of the country itself. Unfortunately, Section 124A, because it was drafted in the colonial years where it had to protect king and country, and therefore they had to keep the colonial rule going, has been so widely defined that it is today absolutely untenable in our present day constitution. The point is, sedition can stay, but in the context in which it should be understood, which I've already said, sovereignty, integrity, security of the country. But
No, so
not
are
in
you
its
saying it
present
should stay?
form.
No, no, 1 minute.
124A
Aryama Sundaram, are you saying
cannot-
it should stay on the statute books? Are you saying it should stay on the statute books? Because as I said,
Yes,
once it stays
I
on
am
the statute
saying-
books, given the fact that police powers can be misused, it will be misused again. So when the
Can I
government says
answer
it's
you
going
on
to
that,
review and
Rajdeep?
re-examine it,
I am
what does it
saying
mean?
124A as it stands has to go completely. And if you want something which is akin to a punishment for treason, then enact a totally different section for that. Now, so far as misuse of a provision is concerned, I'm afraid every statute you find misuse. You find income tax officers misusing that provision. You find ED officers misusing their powers there. Now, misuse happens. That doesn't mean the law is bad. It means the exercise is bad, and the courts are there for that purpose, and that will always happen. My point is that the section as it stands today is something which is so capable of interpretation, misuse in every way because of the way it's been drafted so loosely, and this section has to go.
So
You
what
want
can,
to
so
bring
what
in
can
a
the centre
solid
do?
law
No,
against
Aryama
treason,
Sundaram, when the
a
centre
separate-
goes, no, just a minute, sir. When the centre goes to the court and says we are reviewing and reconsidering it 48 hours after first saying it's necessary. Remember, this is the same central government which on Saturday said it's necessary. On Monday files an affidavit saying we are ready to review and reconsider it. Why should I trust the central government that they will review and re-examine it in a manner that will ensure that it is not misused?
Well, what my answer to that will be, it has been very clear that the Prime Minister then took a decision that it was something which needed to be relooked at in view of the views expressed by the court, in view of the general sentiment about it, in view of the fact that it was today, in today's context, something to be relooked at. And the government has made a statement to the court. It is always expected that when the government makes a statement to the court, it says so with all honesty and all bona fides. And I do not
With no
see any
timeline.
reason right now to disbelieve it, nor do I think will the court take this lightly. The court will also see it as the government says they're going to look into it. We take the government, and that's the Lakshman Rekha, which the court has respected and says, look, you, the government, say you're going to look at it. We trust you, but in the meantime, do not utilize the section as it stands, since you yourself say the section has to be revised. You yourself as a government say the section has to be changed.
Sir, just a minute. The next hearing is in July. The Chief Justice retires on August 26th. What stops the government from pushing it well beyond August 26th and allowing it to die down? Once all this brouhaha around it dies down, this will be consigned to some legal cupboard. What stops the government from doing that? Why are you so sure that the government is serious about re-examining sedition suddenly?
Well, possibly, Rajdeep, I have far greater confidence in the Supreme Court of India than what you are afraid of. The Supreme Court of India is not a court which is going to take such a representation of the government lightly. The Supreme Court of India has posted the case to the third week of July. I think you should wait till the third week of July and see what the government comes back with and see how the court deals with it. But the fact of the matter is this: the court has prima facie expressed a clear view that this is something has to be relooked at completely. The government has been responsive enough, at least in the recent past, to say, yes, we also agree. The natural corollary of that was the court said, very well, you also agree it has to be relooked at. We will give you that chance to relook at it, but meantime, we are staying the provision. So as on today, it is as though that provision is a dead letter from the practical point of view. It cannot, proceedings cannot be continued, the section cannot be used, people who have been booked under it can get their bail, and we'll have to wait till July. And I am not inclined to say that the government has said something so lightly and so flippantly that they are going to go back on it. We will wait till the third week of July, see what is said, and I have enough confidence in both the court as well as in the government's words to believe that the government will come up with something, and the court is definitely not going to put this in a back burner. The court has made it very clear that they're going to consider
Mr. Sundaram, as a journalist, the reason I have skepticism is twofold. Number one, a number of people who've been charged with sedition also have serious UAPA charges, anti-terror law charges against them, and criminal conspiracy. So while they may be let off on sedition, there will be other charges. Number two, this is the same government which over the last 1 year, since this matter was moved first 10 months ago, didn't do anything about it. Suddenly, Mahua Moitra, they wake up. Which is why, are you as sanguine as Mr. Sundaram believes, that by July, the government will come up with an answer. There's a parliament session in July. Do you expect sedition law to be re-examined and we'll have a new law by July? Do you really expect that?
I agree with Arama completely on one point, that we have faith in the Supreme Court of India, and that the Supreme Court, the fact that they've posted it for July means that they've definitely put some kind of timeline on it, though the government itself did not commit to any timeline. And like I said, the government cannot commit to a timeline on behalf of Parliament. That doesn't work like that. A. B, the thing is, if it came into Parliament, if it does come into Parliament, I'm sitting in the opposition. I'm in the Lok Sabha. We have seen this over and over again. The government has said nowhere that they will revoke the law. The word they have used is review and reconsider. They could very well bring in an amendment to this, in which they say that in each case, you will have the SP of a district look into it on a case-by-case basis.
Right.
And they have the brute majority in the Lok Sabha to pass it. They now even have majority in the Rajya Sabha to pass it. So we will again be faced with a situation where on the books, this law is there, it's an amended law, and we've got to go in and again, and they've kept their word and said they've reviewed it and reconsidered it. But by the way, the law, for all practical purposes, would remain as it were.
Okay.
So in that case, I think the Supreme Court, and by going to the Supreme Court, we've done the right thing. The Supreme Court, by putting the law in abeyance while the government takes its own sweet time to do whatever it has to do, and giving them the benefit of every doubt, the Supreme Court has laid down all of the sort of protections that citizens require today.
Okay, let me leave it there. Clearly, one step forward.
Sure,
I'm
sure that both you and Mawa will agree that a mere cosmetic change is not going to fool the Supreme Court of India.
I hope so.
That the Supreme Court of India is not going to view a cosmetic change as a real change. And I don't think the government also, when they're saying this, intend a cosmetic change. I'd like to believe that both the government is sincere in what it's saying, and I see no reason to think otherwise. And I have enough faith in our courts that the courts will see to it that this cannot be a misuse provision in future.
Okay, that's the difference
that,
difference between a senior lawyer of the Supreme Court and a not so senior journalist who perhaps has been trained to be very skeptical of what the political executive does. Mahua Moitra and Aryama Sundaram, appreciate you joining us. Der aaye durust aaye is a great saying in Hindi. Better late than never. Hopefully, Justice Ramanna and his bench have sent a strong message, and hopefully the political executive of this country will respond. A law of 1860, which has been misused by the colonial powers, cannot be misused in 2022 by the successors of the Raj. Let's now look at our other big story, and it comes from the neighborhood where the civil unrest in Sri Lanka continues to rise to unprecedented levels. New videos now show military trucks moving out of the capital, soldiers riding on motorbikes, and the army taking over the country. The pressure is now on President Gotabaya Rajapaksa to resign after the resignation of his brother Mahinda Rajapaksa. Akshaya Nath brings you today's ground report, and then we'll have a special panel on the Sri Lankan situation. Take a look.
Blood on the streets. Ministers targeted. Shoot on sight orders. Nation on the boil. Sri Lanka is facing one of its worst political crises in history. Citizens are gunning for their leaders, targeting them and their homes.
At Coalface area, just in front of the old Parliament building, we're seeing youngsters of the state of Colombo raising slogans against the current government and demanding that President Gotabaya Rajapaksa resigns and moves away from the government. And they have been putting up banners like these which says, let's expel the government, let's change the system.
There is open looting in cities. The government is missing. The only semblance of order comes from the military.
The island nation of Sri Lanka is facing one of its worst economic crises since its independence in 1948. We're seeing here that people have taken to the roads, and here behind me at Goldface you can see how people have camped in large numbers and have been protesting 24/7. Their demand is only one. They want the Rajapaksa family to go out of the government system. Already Mahinda Rajapaksa, due to these violent protests that were there, resigned on Monday. We had seen that around 8 people had died here and more than 200 people have been injured. Several MPs have been attacked. Their houses have been burned. Even Mahinda Rajapaksa, his house had been burned. All this is because of the kind of economic crisis, the unprecedented economic collapse that this island nation is now facing.
The Rajapaksas, who have ruled the island nation with iron hand, are now under siege. Mahinda Rajapaksa, who resigned as the Prime Minister on Monday, is facing calls for arrest for inciting violence that claimed at least 8 lives. He is being protected at the Trincomalee Naval Base. President Gotabaya Rajapaksa is clinging to his chair even as protesters demand his ouster.
ये हुकूमत नहीं चलेगा, ये हुकूमत खराब है। क्या है, इंडिया से अभी 1 महीना का पहले 2 बिलियन तो उधार लिया था, उसमें से पेट्रोल, दवा वो लेकर आने के गैस सब ऐसा लेकर भी दोबारा सामान लेने के लिए उन लोगों को पैसा नहीं है। सामान का खत्म होता है, दोबारा लेने के लिए पैसा नहीं है। ये पैसा कहाँ जा रहा है?
Sri Lanka suffered nearly 3 decades of civil war when the Tamil rebels waged a war for Ilam. The current turmoil, sparked by an unprecedented economic crisis, could escalate to another long struggle unless the political leadership and the world community come together for a rescue act. With Akshay Nath in Colombo, Bureau Report, India Today.
So Lanka on the boil. Who or what is accountable? What now lies ahead? Is the economic crisis the sole reason for the meltdown? Are there any lessons that South Asia and indeed even India can learn from what's gone wrong there? I'm joined by a very special guest. Dr. Paikisoti Sarvanamuthu is Director, Centre for Policy Alternatives in Sri Lanka. Rajendra Abhyankar was former Deputy High Commissioner of India and Sri Lanka and a senior diplomat. And N. Ram, Director of the Hindu Publishing Group and someone who's tracked Sri Lanka for years. And let me start with you, Mr. Ram. Are you surprised by what you're seeing in Sri Lanka playing out over the last few weeks? Or do you believe this was something that was